Hello, I'm Adele Abrams, and I'm president of the law office of Adele L. Abrams, PC. I'm an attorney and certified mine safety professional, and we have offices in Maryland, the DC area, Colorado, and also West Virginia. And we are going to be talking about workplace examinations, inspections, and audits, and how to take this beyond compliance. And I'm going to be presenting first, and then my co presenter, Glenna Smith, is going to be taking it after that. And we will take questions from you live at the end of the virtual session when it is presented. So thank you for joining us, and fasten your seatbelts. We're going to cover a lot of material here. First of all, what are we going to be talking about? Well, I'm going to be talking a bit in a few minutes about MSHA's new workplace examination rule. And that just took effect in the fall of 2019. Enforcement of that just began. But we're also going to be talking about other types of inspections and audits, both mandated and also voluntary audits, in-house and third party. And so you really have to think about when you're trying to assess your workplace, what are your needs and what are your objectives? What are the benefits of doing different types of these approaches? Because a daily workplace examination done for compliance purposes with OSHA or with MSHA is going to be quite different from the deep dive that you do in a real comprehensive audit, perhaps where you're bringing in third party safety professionals or certified industrial hygienists. But you do audits and examinations to gain knowledge. You want to really understand what is going on in your workplace. You want to identify potential violations for sure, because the cheapest citations to defend are the ones that are never issued. And in some cases, you are actually doing these inspections for compliance with OSHA rules, with MSHA rules. We're not talking about it so much today, but environmental rules as well. Many of those require some sort of auditing procedures as well. You also are doing audits in part, especially, and Glenna will talk about this a bit more, when you're bringing in third parties to do audits, because that can give you an unbiased and objective view of your workplace. You're going to be benchmarking where you are. You're going to be looking at what your desired improvements are and figuring out the methodology to get from point A to point B. Validation is a third benefit of the audit process. And many times companies are doing this because they are trying to, again, benchmark themselves to align with some safety, quality, or environmental management system. The ANSI standards, ANSI Z10 would be an example, some of the ISO standards. And also, if you are trying to become eligible to participate in OSHA's voluntary protection program or their baby steps program, the SHARP program, having an audit will really give you a good pragmatic view of your operation and whether you really meet the criteria or what incremental improvements might be needed in order to qualify for that prestigious status. But I'm going to talk as well about some of the legal issues because unless you're managing your workplace examinations, your inspections, and your audits in a proper manner, these really can be used against you. And sometimes I look at it as these audit documents can be a shield. They can prevent you from being cited. They can show that you're compliant. They can be used for abatement or corporate-wide settlement agreements. They can, again, be used for validation in one of these systems. But at the same time, there's a lot of incriminating information potentially that's included in these audits. And so OSHA or MSHA, if they get a hold of these and they are not privileged or protected in some way, they can be used as a sword against the employer as well. And dare I say it, safety professionals have their fingerprints all over these audit reports, the internal ones, as well as the third party ones, because typically you're one of the recipients of those if you're not actually the person as the consultant doing it. And so if you have knowledge of the conditions, it's documented and you can't unring that bell. With that knowledge comes responsibility. You have to respond to the knowledge that you have that conditions are out of compliance, if that is the finding, and you have to take appropriate remedial action. Otherwise, you have a ticking time bomb sitting in your filing cabinet, and if something goes sideways down the road, a fatal accident, for example, And they find out by looking at one of these historical audit reports that you, the safety professional, had knowledge of that structural defect, for example, or the inadequate guarding or the electrical problems, you could be going to prison. It's just as simple as that. So you definitely have to make sure that you're doing these audits with integrity. You have to make sure that you're doing them with due diligence, and you have to make sure that you have a system in place to respond to the information that you have acquired through this audit system. Now, if you use these properly, though, they can even be used to offset penalties. So there are pluses and there are certainly minuses to the systems. And Glenna, again, will talk about those a bit later. Now, let's talk about some of the legal and regulatory requirements. And I always like to say this at the outset. OSHA and MSHA, they are enforcement agencies. Yes, they do codify regulations, and most of those regulations come out of 1960s, in some cases 1970s ANSI standards. Sometimes you have really ridiculous situations. The Mine Safety and Health Administration, for example, I do a lot of mining work. Their electrical standards are benchmarked to the National Electrical Code from the 1960s. Now, I would submit that anybody who is wiring up their facilities in accordance with the standards from the 1960s is insane. Just to put it out there. And yet that's all the regulations require. They are the minimum. And you are never going to get cited for going beyond minimum compliance. But you need to really, especially if you're a larger organization, you want to be benchmarking to best practices within your industry sector. And if you're multinational, you're going to be taking into consideration things like the EU standards that may be more protective in some ways than what we have codified with OSHA or with MSHA. So as one of our friends at ASSP likes to say, the Titanic had the appropriate number of lifeboats that were codified and required by law at the time, and yet we all saw how that turned out. So part of the auditing process is not just looking at, are you complying with the bare minimum amount of things that you need to, but how can you go beyond compliance so that you're really protecting your workers to the best of your ability? Because after all, they are your most valuable resource. Now, some OSHA standards as well as MSHA standards require what could be considered audits, and I'm doing the air quotes there. And those you have to disclose to the agency upon request. Which ones are those? Well, very simple. As I like to say to my clients, read the rule. That's what I do. I can't keep all of it in my head, but if the standard says you shall make a record and make it available to OSHA upon request or MSHA upon request, you've got a mandatory record there. And if it's an examination of workplaces for MSHA, or if it's the slip, trip, and fall inspections you're doing under the general industry standard that came out in 2016, if you are doing your construction worksite examinations and walkarounds, if you are assessing your compliance with your silica written exposure control plans, those are all types of examinations and plans that you do have to share with OSHA and with MSHA. Your PPE hazard assessment, that is a form of audit. You are doing an industrial hygiene audit of sorts when you are preparing that, because you're determining what are the hazardous chemical exposures you have. Do you need respiratory protection? Do you need a special type of gloves for chemicals versus for splinter hazards? Are you having to wear eye goggles? What type? Do they need sides? Those are all things that you can really only determine with any precision after you've done a good workplace audit and determined the scope of all of the hazards that you have there. So you also have some more complex audits that are required under the process safety management standards and under OSHA's HAZWOPER standards. If we were doing the whole 90-minute version of this, we'd probably be going deep dive into some of those standards. But today we're going to be, trying to focus more on the high level approaches to audits and examinations. But I do want to note that sometimes you may be contractually obligated to do audits. And in some cases, you're doing those for private purposes. In some cases, they may be public-facing audits. A contractor I'm working with right now, one of the requirements from the GC was that they share all of their audits. Well, we're going to talk about legal privileges here in a few minutes, but even a privileged audit, if it is shared with a third party who is not in the privilege loop, like a general contractor, for example, you have just blown your privilege out of the water. And those documents now are going to be accessible by OSHA and by MSHA. But you have to be aware of what's in your contracts. Now, just as an example, in certain cases, you might have to benchmark to, say, in construction, the ANSI A10.33 standard. That's for safety and health management programs for complex construction projects. There are workplace inspection requirements that are built in to that consensus standard. So, OSHA can't enforce that, but the general contractor might be able to. And audits are how you're going to document compliance with these programmatic elements. So bear in mind that OSHA and MSHA are not really the only thing you have to worry about here. I also just want to note that we have many work sites now that have a mix of your own employees. There may be non-employees from staffing agencies, or there may be subcontractors. And you don't have a workers' comp exclusive remedy with them if they are injured. And these audit reports, again, that document what did you know and when did you know it, they can be seized upon by a plaintiff's attorney in a personal injury or a wrongful death action to show knowledge in advance of what went down. And if Glenna is the auditor on that, and no action was taken as a response, and then somebody becomes injured or is killed as a result, in some cases, those safety professionals can have personal liability severally and jointly with the host employer, who would be the primary defendant. So there can be some flow over tort liability here if you do not have workers' comp as an exclusive remedy. Now, we've talked about some of the mandated audits, and I just want to note that there are other categories. Glenna is going to go into this in more detail, but you have some audits you're doing to benchmark regulatory compliance. If those are not required by a standard in the 29 CFR for OSHA or 30 CFR for MSHA, then you don't have to share them right out of the gate with the agency. But they will be able to be obtained by virtue of subpoena. We're going to talk about that. And MSHA has their own ways of getting at things. So if there's not a standard requiring it, it falls into the voluntary category, but it may still be discoverable. Accident investigations or near-miss investigations, those can be ticking time bombs again, because if you are doing this without it being privileged, and you're being very robust in your analysis, you're going to be admitting fault, and you're probably going to be admitting to some violations. I even had a case where a safety professional did their whole fatality investigation without counsel. They thought they had a good relationship with the agency, and they were shocked when they got, about 150,000 in penalties. So I was retained, and they handed over their accident investigation report to me. The safety professional in there had listed 5 standards that he had identified that they had violated. Well, then they got their citation packet, and there were 3 citations. Good news, right? Except we had to turn over that accident investigation report as part of discovery. And as a result, they were able to write 2 more citations because the safety professional's information in that report was considered an admission against interest by a party opponent. So you have to be very careful how you write things up that are going to be discoverable. Hazard and whistleblower investigations, especially those that cross over into the HR employment law side of things. I have a mention of it in another slide. The Farraher-Ellerith decision basically says if you're relying on the fact that you're doing your own internal investigations as a defense against discrimination or retaliation claims, those reports now become discoverable in court. So don't think that you can keep those private if you are planning to try to utilize them as one of your factors in defense. And then, as I mentioned, there are other types of audits. Corporate-wide settlement agreements is a very common approach with OSHA. Not so much with MSHA, but OSHA, especially if a company has not had a good safety program or a non-existent safety program, they might say as a condition of settlement, you need to bring somebody in, do an audit within 6 months, and then share the audit with OSHA. They might require that at multiple locations. So that's an example where you could bring in a third-party auditor, but you're not going to be able to keep that audit confidential because you're doing it as part of your abatement of citations. Some companies are in states where you have mandated safety and health committees. Some companies are union and you have mandated safety and health committees from that perspective. They may be required under your collective bargaining agreement. In many cases, the bylaws of these safety and health committees specify that either any audits that are conducted will have members of the safety committee participate, or that the audit reports will be shared with the Safety and Health Committee. If you are privileging audits and you share them with hourly workers, you have dissolved that privilege. So you have to be thinking in advance, what is going to be the end use of the audit and who is going to be the ultimate audience for this, who are going to be the recipients. For anything that's privileged, you need to keep that within a control group of senior management officials. I've gone so far in some cases as to number the copies, and we know who each numbered copy went to, and upon pain of death, basically, you cannot share that with anybody else. In some cases, you want to keep them on a thumb drive rather than putting them on a server that could be accessed by anybody without a password. Sometimes you have to do audits as part of your insurance requirements. And, again, if you are doing these and sharing them with your insurance company, there is no privilege on that. And then finally, as we talked about, part of the certification process, or you might be doing these as a way of implementing your injury and illness prevention programs. So I've talked about privilege quite a bit already, and what am I talking about? I'm talking about not creating documents that do not have to be turned over to the enemy, whether the enemy is a tort attorney or whether it is somebody from a regulatory agency that's trying to find your company or perhaps build a criminal case against you. If these are in-house inspections or audits, generally there is no privilege. And even if in-house counsel has directed them, these very often, and it depends what court you're in, but very often they look at those as business records that are prepared in the normal and customary course of business rather than an audit or any kind of document prepared in anticipation of litigation, which is the hook for something to be privileged if it is prepared by a third party. Now, anything an attorney writes up, whether it's an audit report or a letter summarizing an audit or any other communication with my client, that is totally privileged. They're not going to be able to pierce that. The attorney work product can be very successfully asserted. But again, you have to label these documents as privileged. You have to control the circulation of them. And most critically, they have to be prepared at direction of counsel in anticipation of litigation. With MSHA, that's easy because you're always in anticipation of litigation with them because they inspect you twice a year, whether you need it or not. With OSHA, you have to be sometimes a little creative on that. But the point is, you cannot prepare the report first and then call the attorney. You have to talk to the attorney first. And even for third parties, let's say I was hiring Glenna's company to do audits for me under privilege for my client. I would direct her to do that. She would label her report privileged. She would send the report to me, and then I would transfer it to the client so that it's all being kept in that attorney communication privilege chain. As soon as you start giving these, though, to union members or to third-party contractors or anybody else on the work site who's not in that kind of senior level zone, you're going to get into trouble. You do have to label the documents as privileged, but Again, as noted in this BHP Copper case, one of the Federal Mine Safety and Health Review Commission judges specifically said that she doesn't consider these to be privileged. There is a similar holding in the Court of Appeals for the Fourth Circuit, which happens to be in the Maryland area, Maryland, Virginia, West Virginia. But having said that, always try to assert the privilege because another judge, another jurisdiction, they might look at it quite differently. So the attorney work product privilege, which I've talked about already, is recognized under the federal rules of civil procedure. Again, has to be directed by counsel, but it does extend that privilege. So very often, for example, you know, aside from the audit direction that I give, say there's an accident on site, I might deputize the safety officer for the company to gather some information for me or to prepare some of the reports or take witness statements. And as long as those are labeled as privileged under the attorney work product doctrine, we can usually keep those from discovery. There are a couple of types of packed work product and core work product. We don't really, this is more for your information. We don't need to dive into that. There are a very few circumstances where we can kind of cobble together a bootstrapping where materials that were created prior to the events giving rise to the litigation can still be privileged if it's done with an eye toward anticipated litigation. You know, we have done this. We had an engineering firm come out and do a structural audit at one of the mine sites I work with, and they gave us some information back about recommendations they had for some of the capital improvements. We did that under attorney work product privilege in anticipation of litigation because we knew that MSHA was doing a lot of work looking at structural integrity, especially of certain types of structures. And so we were anticipating litigation there. Now, you can waive that privilege way too easily. That's the problem. So watch out for putting things on a server that is not protected in some way. Again, getting it outside of your control group or sharing it with third parties. And the Farraher-Ellerith defense, if you've affirmatively invoked that, and this most often comes up in whistleblower cases or sex discrimination cases, and you're trying to claim, look, we did our due diligence, we did a good, robust internal investigation, we audited our records, you know, we made sure we were, you know, treating everybody in a similar manner. That report now is going to be discoverable. And then the last privilege waiver, which I did not mention, is the inadvertent one where you hire someone who's going to be a testifying expert in a trial. Maybe there's been an accident. Um, Anything you share with the testifying expert becomes discoverable because if they've based their opinion on their review of a document, the opposing party has the right to question them about, you know, that document and the impact it had on their opinions. And so you have to be careful never to share audit reports or other things unsolicited from with the expert unless you want them to be able to be shared with the opposing party. You can verbally go over things on the phone with them. I do that all the time with experts. But as soon as you give them that document, and I had this happen to me, even attorneys' notes and memos shared with a testifying expert, the privilege is gone on those. Very quickly here, OSHA has a policy on self-audits and that is something of a safe harbor. They encourage this. They'll even give you some money off of your penalties if you have a good audit program that's been ongoing. You know, as I mentioned, sometimes for abatement purposes, they encourage you to do audits. And their position is that if you've identified violations as part of your hazard assessment in an audit, and you have corrected the condition before OSHA shows up, they're not going to cite you for it. That is generally the rule, but it is not absolute. It is something of an illusory safe harbor because they can still use those reports to show a pattern or practice of problems. You know, they can, and then of course, if the issue reoccurs and you've had this this problem, continuously, and you're doing a Band-Aid solution instead of performing surgery on it to fix the issue, that could heighten it up to a willful violation on the OSHA side. So they reserve the right to use self-audits to prosecute employers, and they have even subpoenaed insurance company audits in the past in order to use those against the employer. Many people think that they have some kind of privileged relationship with their insurance agent. They do not. Those documents, absolutely, the U.S. District Court in Illinois held in the Grinnell case that OSHA did have the right to those documents. And OSHA says, look, it's the best way we can show what the employer knew and when they knew it for purposes of establishing a willful violation. But again, if these documents are privileged, then the issue doesn't come up. You cannot privilege photos. You cannot privilege videotape. You cannot privilege audio tape, and you cannot privilege drone footage. Now beyond that, though, the findings in these audit reports, the recommendations, all of the textual information, that can be privileged. Sampling results cannot be privileged. And of course, those need to be shared with your workers anyway. So when you're putting your audit reports together, I always like to see, the text in one place, and then let's have a package of pictures elsewhere as an addendum so they can be separated if we do need to produce stuff to OSHA. Now, what about MSHA? Well, they have no safe harbor whatsoever. No self-audit privilege. There was discussion as they were developing their new workplace exam rule, which I'm going to talk about in a moment, whether or not they should adopt a policy similar to OSHA's. And they said, nope, no can do. Our statute doesn't allow it. The Mine Act is a strict liability statute. MSHA has warrantless search authority, and there's no statute of limitations. So if you do audits and MSHA gets their paws on them, even if it's 5 years ago, if you admit that you found a whole section of guarding that was inadequate, technically, MSHA can write you a citation based on that. And so it's more critical, I'd say, than even in the OSHA setting to try to privilege reports of audits that you're doing at the mine site. Now, the good news is MSHA has very limited subpoena power. They have to convene a public hearing in order to get subpoenas. But the bad news is that they have statutory provisions that allow them to circumvent the subpoena process. And again, warrantless searches. So Section 103A of the Mine Act allows them to come in, whether you want them in or not. You can't stop them at the gate. If you do, they will get the marshals. And beyond that, they can issue you a citation under Section 103A for impeding their inspection or investigation. And I had this come up one time when the client insurance company refused to turn their audit records over to MSHA, and they cited the mine operator saying, well, you've got the relationship with the insurance company. You have the power to force them to disclose these documents. They have Section 103H, which is audits that tie in with verification of injury and illness data. They also have 30 CFR 50.41 for failure to produce information on accidents, injuries, or illnesses that MSHA considers relevant. And they even use that for auditing of quarterly hour reports. And then finally, MSHA has a little used but fairly draconian power under Section 108A1E of the Mine Act, which allows them to go into U.S. District Court and get an injunction to compel production of any documents, including any non-privileged audits, that they believe are necessary to carry out their activities under the Act. That is so broad you could drive 2 Mack trucks through it. And they didn't use it for probably 30 years. Then they went to court, they got their first injunction, and now almost every document request that we get from MSHA, they throw that in there as a caveat that if you don't comply, we can drag you to court and get an injunction. So I've mentioned subpoena powers. OSHA does have them. There's 2 types. One is for testimony, and that is a testimonial subpoena. And the second one, more pertinent here, is a subpoena duces tecum, which is a subpoena for documents. They can issue these before any citations are issued. So this is still in their first 180 days of investigating the case. They send them to the employer, they send them to third-party consultants and auditors, insurance companies, general contractors, other subs that might be on the project. Um, the most expensive OSHA case I ever handled, which was over $500,000, the majority of that case was built upon the subpoenaed testimony and documents of a third-party consultant. So again, the consultant's information was used against their client, the employer. And of course, if you don't speak to them, they can use a subpoena to drag you in there to give a statement as well. But MSHA does not have that power. They really don't need it because they have all those other powers. So again, very quickly, MSHA does have a new workplace exam rollout, and this had a long and checkered history, I guess, without taking up a half an hour to explain it. The short answer is the new rule took effect technically on September 30th, 2019, but MSHA started enforcing it January 1st, 2020. You now have to do a workplace exam every shift of every active work area of the mine. The mine operator has to do it, and every contractor on the site has to do their own as well for their own work area. The person doing it has to be a trained, competent person. That training on doing the task of workplace examination has to be done and documented under Part 46 or Part 48 training. The workplace examiner has to make a note of every hazardous condition that they observe, even if they immediately correct it. And that's one of the big changes in this rule. So if the trash can lid blew off overnight and you pick up the trash can lid and put it back on, the rule requires trash cans to be covered. You've got to put that on your form now. And then if things are not immediately corrected, you have to go back to that record when it is corrected, maybe 2 or 3 days later, and annotate the record with the date it was fixed. The initial record has to have the name of the competent person who does the examination, but the person amending the record who did the fix, their name does not have to go on the record. In addition to that, you have to notify all miners of the hazards you found that have not been immediately corrected. If necessary, use barricades or other methods to danger off the area until it can be addressed. If there's an imminent danger, under this rule, the competent person has to immediately withdraw all miners until it's corrected, other than those people who are functionally going in there to actually correct the problem. And then you have to keep these records for 12 months, make them available to the miners, and make them available to MSHA upon request. MSHA's now saying, and there's court decisions upholding this, that if multiple problems are found by MSHA at the time of an inspection, in their view, that may mean that the inspection was inadequate, and they can cite you not only for the problems, the missing guard, the housekeeping issues, maybe the electrical problems, but then they can tack on a citation for an inadequate workplace examination, and they can also tack on one for inadequate task training of the examiner. So they really can do kind of a triple dip on this. In addition, if they withdraw your competent person for lack of training, that is considered an elevated action. And if you are a publicly traded company, you have to report that to the Securities and Exchange Commission. Beyond that, the Sunbelt Rentals case has gone back and forth in the courts, but this stands for the proposition that all of the contractors, like they say, turtles all the way down. In this case, the host employer, who was a cement company, they got cited. The GC got cited, and then Sunbelt, who was the sub, got cited because Sunbelt did not do an adequate workplace examination. And this went all the way up to the commission. It is binding precedent. MSHA has unreviewable discretion as to whether to cite the host employer, the GC, or others for a subcontractor's violation. And this case also not only established that the inspection must be adequate, but it also established this reasonably prudent person test, which is now being used to determine whether the inspection was adequate. Would somebody who's reasonably prudent, familiar with the factual circumstances around the hazardous condition, including facts particular to the mining industry, recognize a condition that warranted correction? So there's lots of things to inspect at mines. This is not an exhaustive checklist by any means. MSHA has said that things like administrative buildings, parking lots, lunchrooms, break rooms, and toilet facilities do not have to be included in your workplace exam, but they can still cite you for problems in those areas or if somebody gets injured in those areas. And then MSHA has a lot of frequently asked question information on their landing page about this rule. But basically, I pulled a couple of them out here. As far as the competent person, the mine operator gets to pick who they are, and it can be a salaried person, a supervisor, or it can be an experienced hourly miner. They just have to have the task training on the task of doing the workplace exam. Are they an agent of management? Maybe. There is case law that suggests that they are, even if they're hourly. MSHA backed away from that a bit during the rulemaking, but stay tuned. What needs examination? It's all active work areas, including travel ways to get from point A to point B. So you have to check the berms on the roads and look for tank traps and big boulders that might have fallen off a truck. And then the examination has to be done before miners enter the work area to commence work. And it also needs to be done sufficiently close in time to when they're going to start doing work in that area so that conditions won't have changed appreciably because the mining environment is ultra hazardous and it is a dynamic environment. But if you have consecutive shifts, you can do the next exam at the end of the preceding shift as long as the information about hazards is communicated to the miners on the following shift. But you cannot, if you're an operation that closes at 5 o'clock, you can't do your exam at 5 and consider that to count when you reopen the next morning. So those are kind of the main issues on that. And then finally, as I've mentioned, the OSH Act and the Mine Act are criminal statutes. If you aren't aware of that. And if you falsify any documents, including audit reports, that you give to them or you give them false statements about these reports, that can be criminally prosecuted and it actually carries more time in prison than willfully killing a worker. So don't falsify any documents. The last criminal case I handled last year literally concerned falsification of pre-shift examinations. And MSHA and OSHA also can use 18 U.S. Code for things like obstruction of justice and conspiracy, which takes you out of the 1 to 5 year range under the OSH Act or Mine Act and gets you into maybe 20 years in the federal pen. You also cannot cook your audit books under the Sarbanes-Oxley Act. If you're doing audits for shareholder purposes, you have to keep an eye on that. But if you are retaliated against because you did a truthful audit, uh, safety, health, or environmental, remember you have whistleblower protections as well under the Sarbanes-Oxley Act. So, we've talked about all of these pitfalls. If MSHA or OSHA ask for your audit documents, tell them to put the request in writing and then have counsel or somebody experienced within your company review the documents before you just hand them over. You do have the right to, even with a subpoena, to file a motion to quash that subpoena and keep it potentially from being discoverable. So you have legal mechanisms. You're not forced to automatically comply with a subpoena. And beyond that, again, don't go down this audit path unless you have management support to commit the resources to correcting the conditions that have been found that are hazardous or otherwise non-compliant. So I'm going to turn things over now to our next speaker, Glenna Smith. I hope I didn't step on your time too much.